Hi, I'm Mark Biernath. I'm an estate planning attorney here in the Atlanta area. Today we're going to be looking at planning for your incapacity. In particular, we're going to be looking at some of the uses and limitations of powers of attorney and revocable living trusts. And then we're going to move into a discussion, an extended discussion, on guardianship. We will start our discussion with powers of attorney. It's important to understand that an individual can only grant decision-making authority for themselves. They cannot grant decision-making authority for another person. For instance, a parent cannot grant to a cousin or a nephew or an aunt or uncle the decision-making authority regarding an adult child of theirs. And in Georgia, anyone over the age of 18 is considered an adult. So in order for us to look at these issues, we're going to go to a seminar that I recently conducted up in Summerville, Georgia. When we deal with incapacity, it matters when the incapacity started. And incapacity is a legal definition. And we're going to get to what it means in a little bit, but everybody kind of has a sense as to what incapacity means. We're going to look at what the court looks at in a little bit. But the age of onset of the disability matters. If the incapacity is from childhood, so below the age of 18, and if you have children under the age of 18, by law, they are incapacitated. Isn't that nice to know?
We can convince them.
Exactly. As a minor, they do not have capacity to enter into contracts and things like that, which is a problem for like a child star. You know, they might want to sign a $1 million contract with Disney, and they can't. So the court has to get involved in those things. But for our purposes, if the disability, the condition that is resulting in incapacity starts before age 18, you are limited with what you can do. If it starts after 18, there are some things you can do so long as you do it before the actual incapacity starts. So when we're going through this, think in terms of not only your child or the loved one you're thinking about for who has a disability, but think also about yourself. Because this is a situation where any one of us at any given time could suddenly find themselves incapacitated. Alzheimer's is one of the more common ones. Getting whacked on the head is another one. Being in a car accident and in ICU is another one. You know, all of these things can happen to any one of us. So don't just be focused on your special needs child. Think also about yourself as we go through this. So we're going to talk about what we can do in advance, the advanced planning or using powers of attorney and trust. And then if we don't have that as an option, we're going to talk about guardianship and conservatorship. Durable power of attorney is a document which allows your agent, and an agent is somebody that you've empowered to act on your behalf when you are either unavailable or incapacitated. Common powers of attorney are like if you want to do a closing and you're not actually going to be there for the closing, you can sign a power of attorney to allow someone else to act on your behalf for that closing. That's a pretty common thing that people are aware of. Powers of attorney can be either broad or narrow. That closing power of attorney is a very narrow one. It's for one transaction on one day at a certain specific time. Once that day expires, once that transaction expires, once some event happens, that power of attorney disappears. Or it can be very broad. And the statutory form is very broad and simply says anything that I'm able to do, I want someone else to be able to do on my behalf. Trouble with a really broad definition like that is a bank might not really think that that's a valid power of attorney, even though it's in the statute. There's no law that requires them to accept it, so they might just say, you know, we don't know if you actually intended this person to do this transaction, because the power of attorney just says anything I can do. And so we sometimes will see a situation where a bank will refuse to use a power of attorney or accept a power of attorney simply because they don't think that the principal, that's the person who grants the power, that principal actually envisioned doing this particular transaction. So broad is anything that I could do, my agent's allowed to do. Narrow is to perform that specific item. Georgia does not presently have a law that requires any financial institution to accept a power of attorney. We are moving in that direction. The new guardianship code, which came online probably about 2 years ago now, specifically defers to powers of attorney. So a judge must inquire if there are any powers of attorney in place, and if so, give those powers of attorney deference. But the bank can still say, yeah, we don't think these are valid anymore. We're not going to accept them. And it's pretty simple why they do that. Usually it's good business for them to accept powers of attorney and allow people to transact business that way. And generally what we find is if you have a closer personal relationship with your banking partner, it's going to happen. They're going to do it. You get to a less personalized banking situation, the more likely they're not going to accept it. Usually what I find with a bank is they'll say, oh, we'll accept the power of attorney so long as it's on our form here. Trouble is, power of attorney is not durable, which means if you become incapacitated, it's no longer good. Most people are doing this in case they become incapacitated. And the other is, usually there's some time limit on that power of attorney. Usually what I see is 30 days.
In this section, we discuss some of the issues related to financial power of attorney. In the next section, we're going to focus more on healthcare decisions and Georgia's new Advanced Directive for Healthcare. So please join us.